Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Back in March, I previewed the case of Sylvia Gonzalez versus Trevino. I came away from the review of the oral argument with the conclusion that maybe they hadn't been real sympathetic toward Sylvia Gonzalez. But I'm glad I was wrong. Here are some of the things I said initially about the case. There are two critical concerns in the Gonzalez case. The first of those is whether objective evidence of intent derived in the record from this case, the affidavit of the police officer alone, shows, retaliatory motive. Whether that objective evidence is sufficient. That's the Seventh Circuit rule. And they don't have to show that other people have not been arrested for the same thing. And the second issue is whether the issue of causal complexity, which is just a fancy way of being unable to look into the bad actor's head to discern what his motivation might be, whether those can be properly dealt with in a case like this. And then the other issue is whether or not there is a warrant, and a warrant will usually cut off the chain of causation. So let's listen to a few questions from the judges. We'll start with Judge Thomas, then move to Judge Sotomayor, then Judge Roberts, and finally Judge Alito.
Of their choosing to punish their critics. I welcome this court's questions.
In Nieves, we dealt with an arrest. And is it different here because you have a warrant process, you have an investigation? Does that break the causal link that we would have in a case just where a police officer arrests the plaintiff?
No, Your Honor, it doesn't. In fact, the fact that warrant exists here helps us for two reasons. Number one, we have an analog at common law, abuse of process, because warrant is a classic legal process. But number two, when it comes to but-for causation, magistrates are required to look at the arrest affidavit in order to issue a warrant. So the arrest affidavit, which we say would not have been issued had it not been for retaliatory animus, is something that magistrates have to take into account, and it is a but-for causation. And as this court explained in Bostock, and just this term in Murray, there could be many but-for causations. Our burden is to show that had it not been for animus, that arrest would not have occurred. That's just one but-for causation, one but-for cause, and we meet that requirement here.
You say that you used abusive process as the analog. Have we ever used that in these retaliation cases?
You didn't, but that was because there was no process. So in Lozman, you had an on-the-spot arrest. In Reichel, you had an on-the-spot arrest. In Nieves, you had an on-the-spot arrest. So
as is apparent from the very short but very powerful opinion by the Supreme Court, I was wrong about them not viewing this particularly in a particularly friendly way. Let's get into the opinion. This is from the opinion that was released today. It's per curiam, which means everybody joins, everybody agrees that this is the right call. In Nieves versus Bartlett, this court held that, as a general rule, a plaintiff bringing a retaliatory arrest claim must plead and prove the absence of probable cause for the arrest. At the same time, we recognized a narrow exception to that rule. The existence of probable cause does not defeat a plaintiff's claim if he can produce evidence that is objective evidence that he was arrested when other similarly situated individuals not engaged in the same sort of protected speech had not been. We granted certiorari in this case to consider whether the Fifth Circuit properly applied these principles. It did not. We therefore vacate the court's judgment and remand for proceedings consistent with this opinion. So just to remind you, when the case was filed, it was filed and immediately met with a motion to dismiss. And the motion to dismiss said that Nieves, the case that we're talking about here as the background, applied, and as a result, the motion to dismiss should be granted. The district court denied the motion on both counts. With regard to respondents, the court held that Nieves applied and the plaintiff did not need to plead or prove the absence of probable cause. Gonzalez sufficiently alleged the existence of objective evidence showing that over the last 10 years, no one in Bexar County was charged under the tampering statute for conduct remotely like hers. With regard to the city, the district court held that Gonzalez adequately pled that the city council, as a final policymaker, engaged in a persistent and widespread practice that was the moving force behind the denial of constitutional rights. Because the motion to dismiss was in a qualified immunity posture, one of my favorite doctrines there, the respondents filed an interlocutory appeal with the Fifth Circuit, and the claim against the city was stayed pending resolution. The Fifth Circuit, over a dissent by one judge, reversed the district court's judgment, holding that Nieves' probable cause rule barred her retaliation claim. So by remanding this, it was sent back to the trial court, and the trial court will eventually hold an actual trial and determine whether or not her rights were violated. Now, normally when a city and the agents and officers get to this point in a case where they know they're not going to get out on a motion, a lot of times they actually pony up and provide some money and some damages to the plaintiff. We'll have to see if that happens, but at least that's the hopeful side of the Supreme Court's ruling here. But let's get back to the opinion. The court takes us through the history. In 2019, Sylvia Gonzalez ran for a seat on the city council of Castle Hills, a small town in southern Texas. While she was on the campaign trail, Gonzalez heard multiple complaints about the city manager, Ryan Rapoli. As city manager, Rapoli was responsible for, among other things, enforcing the city's laws and managing its budget. Gonzalez was elected in May of 2019. Her first act in office was to help gather signatures for a petition seeking Rapoli's removal. Eventually, over 300 residents signed the petition. The petition was introduced at the next city council meeting, where discussions grew heated after various residents rose to Rapoli's defense and spoke against Gonzalez. The discussion over the petition continued the next day. At the end of the second day, Gonzalez was packing up her belongings when the mayor, Edward Trevino, asked her for the petition. Gonzalez indicated the petition was in Trevino's possession, which he denied. He then asked her to check her binder, where she found the petition. Gonzalez claims that she did not intentionally put the petition in her binder and that she was surprised to find it there. Now, those of us with suspicious minds might wonder how the mayor just happened to come up with, look in your binder, because that might not have been the first thing that somebody thought of. Maybe he would have said, look around your work area. Maybe it fell on the floor behind your desk. That isn't what he said. He said, look in your binder. And that really looks like somebody is trying to set her up. Now, I'm reading into this. That's my uninformed opinion, just based on what's in the case here. But it really stinks to high heaven. And if that was the case, boy, somebody has absolutely no sense of honor or dignity. Getting back to the opinion. Trevino brought this incident to the city's police attention, and an investigation into these events soon began. Within a month, a private attorney tasked with leading the investigation concluded that Gonzalez had likely violated a Texas anti-tampering statute that, among other things, prohibits a person from intentionally removing a governmental record. On the private attorney's request, a local magistrate granted a warrant for Gonzalez's arrest. When she heard the news, Gonzalez turned herself in and spent an evening in jail. The district attorney ultimately dismissed the charges. Gonzalez claims that this episode has convinced her to step away from political life, which is really a loss for the citizens of Castle Hills. Gonzalez brought suit under Section 1983 in federal district court against Trevino, along with the police chief and the private attorney in their individual capacities. Her complaint alleged she was arrested in retaliation for her role in organizing the petition for Rapoli's removal, and that the defendants therefore violated her First Amendment rights. To bolster her claim, Gonzalez alleged she had reviewed the past decade's misdemeanor and felony data for Bexar County, where Castle Hills is located, and that her review had found that the Texas anti-tampering statute had never been used in the county to criminally charge someone for trying to steal a non-binding or expressive document. Gonzalez's search turned up 215 felony indictments, and she characterized the typical indictment as involving accusations of either making fake government identification documents or using them. Other felony indictments included one for fake checks, hiding murder evidence, or cheating on government exams. Every misdemeanor case, according to Gonzalez, involved fake Social Security numbers, driver's licenses, or green cards. Gonzalez pointed to this research as evidence that the defendants had engaged in a political vendetta by bringing a sham charge against her. The defendants moved to dismiss the complaint. They argued the presence of probable cause defeated Gonzalez's retaliatory arrest claims against the individual defendants. The district court denied the defendants' motion. Although Gonzalez conceded that probable cause supported her arrest, the court allowed her claim to advance after finding that it fell within an exception to the no probable cause rule that we recognized in Nieves. The Fifth Circuit reversed that decision on appeal. The court thought the plaintiff's claim could fall within Nieves only if the plaintiff proffered comparative evidence of otherwise similarly situated individuals who were engaged in the same criminal conduct but were not arrested. Gonzalez's claim failed because she did not provide such evidence. We granted certiorari. Now we get into the court's reasoning. Gonzalez seeks reversal on two grounds. First, she asks us to reject the Fifth Circuit's rule that plaintiffs must use specific comparator evidence to demonstrate that they fall within the Nieves exception. Second, Gonzalez contends that the Nieves no probable cause rule applies only to claims predicated on split-second arrests rather than deliberative ones. We agree with Gonzalez that the Fifth Circuit took an overly cramped view of Nieves. That court thought Gonzalez had to provide very specific comparator evidence, that is, examples of identifiable people who mishandled a government petition in the same way Gonzalez did but were not arrested. Although the Nieves exception is slim, the demand for virtually identical and identifiable comparators goes too far. We recognize the Nieves exception to account for circumstances where officers have a probable cause to make arrests but typically exercise their discretion not to. To fall within the exception, a plaintiff must produce evidence to prove that his arrest occurred in such circumstances. The only express limit we placed on the sort of evidence a plaintiff may present for that purpose is that it must be objective in order to avoid the significant problems that would arise from reviewing police conduct under a purely subjective standard. Here, Gonzalez provided that sort of evidence. She was charged with intentionally removing a governmental record. Gonzalez's survey is a permissible type of evidence because the fact that no one has ever been arrested for engaging in a certain kind of conduct, especially when the criminal prohibition is long-standing and the conduct at issue is not novel, makes it much more likely that the officer has declined to arrest someone for engaging in such conduct in the past. Because we agree with her first argument, we do not need to reach the second. We vacate the judgment below and remand the case to lower courts to assess whether Gonzalez's evidence suffices to satisfy the Nieves exception. And of course, we know that it satisfies the Nieves exception because the district court held that it satisfied that exception when it initially denied the motions to dismiss in the case. I can't tell you how good I feel about the outcome in this case because it is important and certainly good for Ms. Gonzalez. It's good that you're holding people accountable for an arrest that was predicated on a sham to begin with. They knew that she hadn't intentionally tried to walk off with the petition. For heaven's sakes, she gathered the petition signatures. It was important to her. She would have had absolutely no interest in taking that petition out of the government building. Instead, what is much more likely, and what a jury will obviously be able to figure out when this case goes to trial, is that Trevino set her up. That's what I have for you today. I'm happy for Sylvia, and I think the rule of law has taken another small bite out of that governmental immunity exception. And that's a good thing for all of us. If you have the opportunity today, do something nice for somebody. Drop any comments down in the comments below or email me at the address above. And come on back here tomorrow and we will sit down and have another discussion about something else, maybe another SCOTUS case. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.